two paragraphs there, indicated there, counsel assisting the Commission makes various other assertions in counsel assisting submissions in respect of Mr Fotis that do not culminate in counsel assisting the Commission submitting that a finding should be made against Mr Fotis, except for the one finding that he has sought. The second paragraph being, any submission of counsel assisting the Commission that is adverse to Mr Fotis is without a firm foundation and has resulted from cherry-picking the evidence. For example, counsel assisting submits at paragraph 150 of his submissions, it is submitted that Mr Fotis' evidence as to his knowledge of the assault on ARN is implausible and should be rejected. However, the basis for this submission wholly ignores the evidence of Ian Bradford, which is consistent with Mr Fotis' relevant evidence and was left unchallenged by counsel assisting the Commission. And in the light of the totality of the evidence, it is not open to the Commission to reject Mr Fotis' evidence or part thereof as implausible. They're the things that I wish to flesh out today in relation to that submission of counsel assisting. There are some other things then I do wish to deal with, but I'll mention them at the end of these submissions that deal with this aspect. So they go essentially to two things. One is various assertions and submissions that don't go to a finding, and then very specifically that submission, although it doesn't seem to go to a finding, doesn't seem to have any real relevance in my submission, but it's worthy of note, according to counsel assisting, that Mr Fotis' evidence as to his knowledge of the assault on ARN is implausible and should be rejected. So I'll deal with that one specifically as well. So dealing with the first, I'll deal with a couple of things that are dealt with in those submissions of counsel assisting. I might just indicate that in my submission it's surprising, with all of the resources of the Commission, that those resources being something in excess of $400 million, that counsel assisting at footnote 71 of his submission relies on a handwritten document by this crack investigator Stuart Pearson, who at the relevant time had no authority to access criminal records data to support his submission that Mr Fotis, as at 1987, that is prior to Mr Fotis' engagement with Knox Grammar, had a criminal record, being a record including convictions for offensive behaviour, assault, female, and refused to leave licensed premises. The submission I make is that that handwritten document is flawed as containing false information, and I make the submission that it is within the knowledge of counsel assisting that that handwritten document is inaccurate and an unreliable document, being a document that falsely details Mr Fotis' criminal convictions. Irrespective of counsel assisting knowing that that document is false, is relied upon it in those submissions, perpetuating that defamation of Mr Fotis. And as I indicated to the Commission earlier today, it's not in the public interest to do so, to perpetuate that untruth. To be very clear about it, make the submission that counsel assisting knows that Mr Fotis at all times that he was employed by Knox Grammar or prior thereto did not have a conviction for offensive behaviour, assault female, or refused to leave licensed premises, as was falsely asserted by investigator Pearson. I note as well that investigator Pearson appears in some way to have accessed some sort of criminal records data, although he was clearly an unauthorised person to do so at that time. Depending on how he did it, he may well have committed an offence. I'm assuming, given his experience in the police force, that he didn't commit such an offence, and that may well go to explaining, to some extent, the inaccuracies and unreliability of what he's described in that document. Further, counsel assisting relies upon the Master on Duty's daily report for 23 November 1988, completed by Ian Bradford at footnote 75, to support the proposition that in the early hours of the morning of 23 November 1988, one of the residents of McNeil House, ARN, who was 14 years old at the time, was sexually assaulted while he was laying in his bed in one of the dormitories. I draw to the Commission's attention that nowhere in the Master on Duty's daily report for 23 November 1988, completed by Ian Bradford, is there a report that, of that note. That is, he did not report in the early hours of the morning of 23 November 1988 ARM was sexually assaulted while he was laying in his bed. And in fact, the Commission may recall that Ian Bradford, in his evidence, his oral evidence before the Commission, indicated that he was unaware of this allegation of a sexual assault until participating in some respect, in some way, with the Royal Commission. So many, many years later. Counsel assisting then also references that particular proposition the statement of a person who did not give evidence before the Commission. That is the statement of ARN. Make this submission that in circumstances where sworn or affirmed evidence was not received about this matter, no finding can be made that in the early hours of the morning of 23 November 1988, ARM was sexually assaulted while he was laying in his bed. Further, by not giving sworn or affirmed evidence before the Commission, there was no cross-examination of that witness concerning that proposition. A consequence of a statement of a witness being relied upon where an interested party has not been granted the opportunity to cross-examine the witness is that procedural fairness will have been denied. Thus, such statement of ARN ought not to be relied upon by the Commission. Resultantly, there's no evidence that's capable of being relied upon that in the early hours of the morning on 23 November 1988, ARN was sexually assaulted while he was laying in his bed. Clearly, Mr Fotis was not here at a relevant time to take any objection to any statement going into evidence without ARN being here and being made available for cross-examination. Mr Fotis was not served with a summons to appear at the public hearing of these proceedings. Now, there was some, for the proposition that further about this proposition that the person who was sexually assaulted being ARN, counsel assisting puts this proposition, that is that the person who was sexually assaulted ARN was dressed in an older style Knox tracksuit and was wearing a balaclava. And then counsel assisting relies on a number of items which are referred to in his footnote, one of them being the unsworn, unaffirmed, uncross-examined statement of ARN with its previously submitted problems. The other is the unsworn, unaffirmed, uncross-examined statement of ARA with the same sorts of problems as the ARN statement. And strangely, with ARA's statement, he doesn't in fact support the proposition which is put by counsel assisting that the person who was sexually assaulting ARN was dressed in an older style Knox tracksuit and was wearing a balaclava. In fact, if you go to ARA's statement, what he says is a hand-touched that is ARA's, not ARN's leg, and ARA's statement does not at any point state that ARN was sexually assaulted. Further, ARA says it was dark at the time, however, could see due to street lighting, but ARA makes no report of a balaclava. Then counsel assisting relies on AST. Now, AST was an unsworn, unaffirmed statement, although he did come along and give evidence. Clearly, Mr Fotis, they didn't get an opportunity to cross-examine him, Mr Fotis not having been served with a summons to appear at the public hearing of these proceedings. Now, in AST, in his evidence, he says at page 12362 of day 18, lines 37 to 40, he says, one night all of the boys were getting ready for bed. While we were brushing our teeth, Fotis approached ARN and said words to the effect, I've got a surprise for you tonight, ARN. Now, ARN in his statement does not corroborate this account by AST. At page 12362 of the transcript, that's day 118 at lines 44 to 45, AST says on that particular night, ARN and another boy, ARA, had arranged to swap beds for the night. ARN, in his statement at paragraph 14, says, one night we all went to bed at the normal time, around 8:30 p.m. from memory, but makes no mention at all of swapping beds with anyone. And AST says at page 12362 to 12363 of the transcript, day 118, at lines 46 through to page 1 on the next page, he says, in the early hours of the morning, I was awakened when ARN yelled out, some faggots got my balls. However, inconsistent with AST's imaginative narration, ARN said in his statement at paragraph 14, I don't remember saying anything. I do remember screaming out to the other boys in the dorm that there was someone under my bed. Page 12363 of the transcript, again that's day 118 at lines 8 to 12. AST provides us with the following bit of hearsay, but he can't recall who he heard it from, helpfully. He says, I was told by someone, but I can't recall who, that the man had first gone to ARN's bed where ARA was sleeping and touched ARA on the bottom. Surprise, surprise, ARA does not report being touched on the bottom. Paragraph 12 of AST's statement, that is exhibit NSW.2022.007.1081.R, AST indicates that ARA and ARN were sleeping in different dormitories on the evening of the alleged balaclava incident. However, ARA said at paragraph 7 of his statement, that is exhibit NSW.2022.007.1182.R, that ARN and ARA stayed together in the same boarding dorm and that ARN was in the bed next to ARA's bed. So my submission in respect of AST's account is that taking AST's account in its totality, the Commission could not be satisfied as to the reliability of AST's account. Then what is relied upon by Counsel assisting is ATD, so the unsworn, unaffirmed, uncross-examined statement of ATD with the same problems as the others, does not support the proposition that the person who was sexually assaulted was ARN. That the person who was sexually assaulting ARN was dressed in an older-style Knox tracksuit and was wearing a balaclava. ATD details an incident in 1998 in his at paragraph 6 of his statement, that's exhibit NSW.2022.007.1202_R. And that date in 1998 just seems to have no relationship whatsoever with this alleged balaclava incident. Further than that, even if he's simply got the date wrong, he does not give an account, that is ATD, does not give an account of a sexual assault upon ARN. He does not give an account of an older-style Knox tracksuit, and he does not give an account of a balaclava. The counsel assisting then attempts to rely upon a couple of other people, but they were clearly not people who had any capacity to witness this alleged incident. The first being Mr. Christoph, and he again, if you have a look at his statement, his unaffirmed, uncross-examined, unsworn statement does not support the proposition that the person who was sexually assaulting ARM was dressed in an old-style Knox tracksuit and was wearing a balaclava. Counsel assisting then attempts to rely on statements of Michael Probert and Investigator Pearson as well, but clearly they had no first-hand witnessing of this alleged incident and couldn't take the matter any further either. In my submission, in relation to the state of the evidence, and this is excluding the fact that the evidence itself doesn't point to an alleged culprit. Sure, repeatedly it's stated throughout various statements and other things that are loosely in this commission called evidence that there was a suspicion about a particular person, another particular person, a third particular person, probably a fourth one. Apart from those suspicions, clearly there was no evidence about who this alleged culprit was. Irrespective of that difficulty with the matter, it's clear that on the state of the evidence without that difficulty, there's absolutely no wonder why that matter was not prosecuted in any way, in that the evidence is truly woeful. Now, we get to Counsel Assisting's submissions that go to this other aspect that I referred to, which seems to culminate in this submission about implausibility of Mr. Fotis' evidence in relation to his knowledge of the assault. Not that even if the Commission was to make such a finding, it goes anywhere, because it doesn't seem to support any finding that ultimately the Commission is asked to make. But in that respect, Counsel Assisting at paragraph 149 of his submissions noted that Mr. Fotis denied speaking with Dr. Patterson or anyone else about the assault on ARN. I draw to the Commission's attention that there is in fact no evidence that Dr. Patterson did discuss the balaclava incident with Mr. Fotis, and that there's no evidence that Mr. Fotis was at any occasion where students were addressed by Dr. Patterson and or Dr. Hawkes about any such alleged balaclava incident, even though various reports indicate there could have been up to about 70 people at such an occurrence. There's also evidence that shortly after the incident, Mr. Fotis ceased residing at McNeil House. There is also evidence that Mr. Fotis was a relatively isolated teacher from other teachers, in that there was no one else that was teaching what he was teaching, and he was not, for teaching purposes, housed with other teachers. And he was typically away from the boarding house overnight for 3, sometimes 4 times a week to be with his wife and child in the Southern Highlands. And that's at transcript day 133, page 13913, lines 25 to 29, and page 13891, lines 15 to 18. And at the very least, twice a week during weeknights. That's on the same day. That's day 133, page 13913, lines 25 to 29, and page 13921, lines 15 to 17. Now, Dr. Patterson did give evidence that he delivered a speech to the boys of McNeil House in which he'd said, "Boys, just leave it in our hands. We are investigating it. Please keep your speculation to a minimum and let's move on." That's the transcript, day 119 at 12444 at lines 31 to 33. My submission is that it's entirely plausible that speculation to Mr Fotis himself, being an apparent suspect, was kept to a minimum. There is no evidence of any person saying particular words to Mr Fotis about the alleged balaclava incident before this commission. What counsel assisting attempts to hang his hat on in this regard is in the submission at paragraph 150 of his submissions, Mr Pearson gave unchallenged evidence that he interviewed Mr Fotis after the assault. So there's opinion evidence of Mr Pearson that he interviewed, whatever that may mean, Mr Fotis after the alleged assault. That in no way is evidence that Mr Pearson provided Mr Fotis with any detail of what was alleged to have occurred. If we go to the references that counsel assisting provides for this submission, that Mr Fotis' evidence is implausible, there are three references. These are the references. The first one is a reference to day 117, page 12261, lines 9 to 36, relying on something that investigator Pearson says. He said, now this is what Pearson had to say, and he said, "My recollection is that I think I might have interviewed Mr Fotis as if he was a witness." Strangely, that's a little different to a statement he'd given in 2009. That being put aside, he said, but trying to establish Mr Fotis' whereabouts in case Mr Fotis was involved. Just as an aside to that, one might expect that there may be some sort of written record of this interview. This crack investigator, having been an investigator and a police prosecutor in New South Wales Police, one might expect, because it is not just common practice, it is standard practice, that a police officer, when taking a statement from a witness, writes it down. They write it down in their police-issued notebook, or alternatively, if they happen to be at a police station, they type it up. This isn't a case of it might have simply just got lost. This is a case where it's not even referred to that such statement was recorded in some way. In fact, investigator Pearson indicates that he just used this generic term, I investigated, in respect of several people, Vance, Fotis, he says some other some other resident masters, and then some of the students. But nowhere is there some sort of indication that this was recorded in some way. Investigator Pearson's mode to simply keep all of this material in his head. I make that submission to fortify the submission that it's most unlikely that, in fact, what's more likely is that such statements were not taken. Investigation in that sort of generic, general, unparticularised sense just doesn't give us the detail that's really required to be able to, for the Commission to be able to make a determination. Well, did Pearson tell Fotis something about this, something about it enough for Mr Fotis to understand that this incident had occurred, and some detail about it? Detail enough that that counsel assisting asks that that the Commission accept. On Investigator Pearson's material, his evidence, best that can be gleaned really from it is that if he did in fact question Mr Fotis at all, in his mind it may have been his investigation in relation to this particular incident. That may not have been imparted to Mr Fotis at all, because what can be gleaned, the only thing that can be gleaned really, is that he was trying to establish where Fotis was at a particular time that was relevant to that matter. It doesn't mean he's imparted any information about this alleged ARN balaclava sexual assault matter at all. There are two other references that counsel assisting relies upon in support of Mr Fotis' evidence being implausible, and the first one being a reference to Day 18, transcript, page 12275, line 4. Now, this reference appears to have no relationship at all to any supposed interview by Investigator Pearson of Mr Fotis. I don't know if it's simply an error, but it just seems to have no relationship at all to it. And then the third one is Day 18, page 12330, line 11. And what it says there is this reference is Mr Watson saying, "I have no re-examination." Can't see anything in that reference that has any relationship at all either to this supposed interview by crack investigator Pearson of Mr Fotis.
I object to that. I just do not know why Mr Pearson should suffer that constant abuse. And I just ask my learned friend to bear in mind, Mr Pearson didn't enter it into his police notebook because he was not a policeman. He was employed by a school. He was a discipline master.
Yes. Right. Thank you. So the discipline master has taken statements from several, probably just less than half a dozen.
Ms Bateman, I do also draw your attention to Mr Watson on behalf of his client taking objection to the derogatory way in which you continue to refer to Mr Pearson, and I think it's an objection well made. So I ask you to stop.
As the Commission pleases. Just getting back to the substance of what Mr Watson said as well, though, about this statement, rather notebook. Sure, he wouldn't have a New South Wales Police issued notebook, but he is telling us that he is an experienced investigator and it's an experienced police prosecutor who then is taking statements about a particular matter from numerous people in a short space of time. I'm submitting to the Commission that the Commission not accept that if that was the case, there wouldn't be a record of it. Surely he wasn't expecting to just keep all of that stuff in his head and keep it all right, name of witness attached to piece of information that witness gave. And there's not a single reference to such documentation being created, leaving aside whether it's now lost with the passage of time. Not even created. So there are a couple of things, really, and that is it may well be well, the Commission doesn't even know what I investigated this matter means. We are just not left with the sort of detail that the Commission can really do much with. We're not even, for example, we're not told by Mr Pearson, I said A to Mr Fotis and Mr Fotis said B. Then I said C to Mr Fotis and Mr Fotis said D. Then I said E to Mr... And there's just none of that. We just don't have that sort of... It's not in a form which the Commission can do really much with, in that it can't say, look, there was unchallenged evidence that Mr Pearson said something to you and therefore you knew something. It just isn't there. The state of the evidence is is lacking in that respect. Now, apart from those difficulties, and I guess that also what that does then, and I've made this submission, but I'll just repeat it, it's very short, is that there is not a single person, not one single witness that has come to this commission and has said, I said to Mr Fotis, and then used words to the effect that included ARN, sexual assault, and or balaclava incident. Just not a single person has said that. Now, when the Commission also looks at Mr Fotis' evidence in the light of Mr Ian Bradford's evidence, again, in my submission, that fortifies the position that what Mr Fotis said is entirely plausible and there is no basis to suggest otherwise. What he said, bearing in mind that Ian Bradford was the resident master on duty on the morning of the alleged balaclava incident, that is not Mr Fotis. He said on transcript 12/750 line 46 to page 12/751 lines 1 to 21. Question was asked of him by Counsel Assisting Mr Bradford. In fact, during your listening to students' conversations, you in fact heard the boys comment that there had been a sexual assault, didn't you? The answer was, I was not listening to their conversations. I made a point of giving them, as I said, giving them privacy, a bit of space. Question was put to him, some of the boys came and spoke to you about the matter. The answer from Ian Bradford, no, they did not. Question, so none of the boys came to speak to you about the matter. The answer, that is correct. Question, so you didn't hear anyone at all in that entire house speaking about the sexual assault? Answer, not to me, no. Question, your evidence is it that the first time you became aware of the sexual assault was as a consequence of this commission, is that correct? Answer, that is correct, yes. My submission is that Mr Fotis' evidence as to his knowledge of the assault on ARN is plausible and should not be rejected by the Commission. As I made the submission before, what is the point anyway? Mr Fotis' evidence on this matter does not appear to go to any finding that the Commission is being asked to make. Again, Counsel Assisting makes the submission that Mr Pearson's rather inadequate evidence went unchallenged, knowing full well that Mr Fotis wasn't at the public hearing, knowing full well that he hadn't been summoned to appear at the public hearing.
Can I just, I don't want to interrupt, but I'll just make it clear that I do not accept that. It's been said 3 times now, and I do not accept that Mr Fotis had not been summoned to appear at the public hearing.
Well, I guess that's something that will be ventilated in another court
Yes.
at another time
Yes.
when Mr Fotis sues people. They are the submissions that I make. They are the matters fleshing out those other matters about Counsel Assisting's submissions. I then wish to make a brief reply to a submission made by the State of New South Wales dated 16 July 2015, where in that submission they submitted that Mr Fotis' submission at paragraph 3.14 of his submissions were misconceived. Now, that paragraph 314 was constituted by 4 sentences. It strikes me that the first 3 probably aren't really perceived by the State of New South Wales as misconceived. The first being that the regulations to the Teaching Services Act 1980 New South Wales made under either Section 99 or 100 of the Teaching Services Act 1980 New South Wales are limited in their scope to regulations that are not inconsistent with the Teaching Services Act 1980 New South Wales. It wasn't addressed in detail, and I suspect that there's no real true issue being taken about that, given that Section 99 and Section 100 of the Teaching Services Act do those things. The second sentence states that the Teaching Services Act only provides for powers or consequences upon the conviction for an offence which carries a maximum penalty of 12 months imprisonment or more. That is a sentence which appears not to be challenged either. Then there's the third sentence, which is the offence of wilful and obscene exposure only carries with it, pursuant to Section 5 of the Summary Offences Act, a maximum penalty of 10 penalty units or imprisonment for 6 months, and that doesn't appear to be challenged. It seems realistic, really, that the fourth sentence is the one which issue is taken with, and that is the submission, which is accordingly Clause 47.1a of the Education Teaching Service Regulation 1982 New South Wales has no operation in relation to a charge of conviction in respect of a wilful and obscene exposure offence. That appears to be the one that genuinely is the one being challenged. And the basis of the challenge appears to be that the regulation itself is clear in its terms. And in my submission, regrettably, that submission simply seems to miss that basic point about the interpretation and application of delegated legislation. That delegated legislation, which the regulation is, must be read subject to the provisions of the Parent Act. And there's authority that talks about it being unnecessary to spell out in the regulation itself all of the limitations on the operation of that legislation, which are imposed by the Act, but that the regulations are read with the Act and the limitations are therefore attached to the regulations. The regulation, in the normal course, does not have to repeat a section of the Act because the operation of the regulation is subject to the Act. As the Court pointed out in Victoria in Barnes and City of Coburg, 1928, Victorian Law Reports at 334, and they went on to say, and any attempt to reiterate the section other than its exact terms would have been invalid, and to have reiterated the section precisely would have been otiose. But it doesn't mean just because you've put it in the regulation that it's not restricted by the Parent Act. It simply is. And if I might draw the Commission's attention to Pearson argument on delegated legislation in Australia, the third edition, 2005, at page 231, published by LexisNexis Butterworths. It is the case, it seems strange to have to make this point, but that parliaments make laws. Entities with authority to make delegated legislation, such as the Director-General of Education, cannot go off on ventures of their own, and that delegated legislation is limited in its interpretation and operation by the Parent Act, irrespective of how clear the regulation may be in its terms. They are my submissions in response to the State of New South Wales submissions that were directed specifically to Mr Fotis' submissions. Now I see that Councillor assisting the Commission made submissions in reply. They don't seem to affect Mr Fotis, so I make no submissions in respect to that. And I do just raise, there was something I raised earlier today. Mr Fotis clearly is pretty cranky about what he views and will be ventilated elsewhere. But what he views is some unlawful behaviour from the Commission in relation to his own person. He says that he's stymied to some extent in commencing and fully litigating those proceedings by virtue of a non-disclosure direction for non-publication that was made on the 6th of February 2015, which names him, and he would like that non-disclosure direction vacated.
So you're formally making that application?
Not actually formally making it at this stage, I'm flagging it. The reason I'm not formally making it is because I've had conversations with Council Assisting about this. He says it has to, in fact, go back before another person within the Commission. So I flag it. I've been instructed to flag it, and I indicate that I will include that application in the material that I send to the Commission within 7 days.
I don't object to that, of course, Your Honour, provided it, like the other application, can be dealt with in chambers.
Yes.
Yes, and in the event that, for whatever reason, the Commission decides against his application, Mr Fotis clearly would seek reasons for the decision so that he can deal with that, if that is the case. Hopefully that won't be the case. I just flag as well that I do have submissions to make some other applications to the Commission concerning not just the redaction of material from submissions, written submissions, but the redaction of some certain things which are referred to as evidence in this Commission, most particularly things which really are just suspicion, opinion, scandalous, defamatory. But
right, so you're going to make those. That's the basis upon which you've sought the 7 days.
Well, I indicated that that is the case for the purpose of seeking a redaction of material from the submissions.
All right.
But I'm also indicating I have instructions
to make reference to other matters.
To the redaction of
other material.
Evidence. Well, what's loosely referred to as evidence in this Commission. That's right. Other materials. Materials. Yeah, that's right. Other than the submissions, the written submissions. There are some other issues which Mr Fotis seeks from the Commission, he says, which may mitigate the Commission or some of the entities associated with the Commission's liability in respect of some matters, but he will raise those matters in that material that will be provided to the Commission within 7 days. And there's nothing further. Thank you.
Your Honour, Fraser for the State of New South Wales. Before Council Assisting deals with anything else, there is one matter in my learned friend for Mr Fotis's submissions I'd like to deal with. My learned friend dealt with the submission in reply of the State in relation to the proper interpretation of the Teaching Services Act and the delegated legislation. I don't take any issue with the substance of much of what my learned friend said. However, it is right that the State's submission is in fact of two parts. One is that the regulation is clear on its face, and I don't need to go into that in any greater detail, but the other is that there is in fact no inconsistency between the regulation and the Parent Act, and I would have thought that was set out fairly clearly in the legislation. My apologies, in the submission. Effectively, it is in fact the second sentence of paragraph 3.14 of my learned friend's submissions with which some issue is taken. That sentence says that the Teaching Services Act 1980 only provides for powers or consequences upon the conviction for an offence which carries a maximum penalty of 12 months imprisonment or more. that's a general statement as to what the Teaching Services Act provides, where in fact the limitation is contained in section 86, and that's a limitation on punishment that may be imposed on a member of the education teaching service having been convicted of an offence which carries a maximum penalty of 12 months or more. The matter to which the particular clause in the regulation, 47(1)A, goes to is not a matter of punishment, it's a matter of notification. And the state would say that there is no such limitation attaching in that regard, and that there is clear power in section 100, subsection B of the Act, which provided power to make regulations not in consistence with the Act with respect to the appointment, transfer, powers, duties and responsibilities of officers and temporary employees of the education teaching service. There's no such inconsistency in our submission. Those were the submissions I'd seek to make in response to those just made on behalf of Mr Fotis. There's just one brief observation in relation to matters raised in the submission in reply on behalf of Mr Weeks, and it's merely a few observations about the document that's relied on in those submissions. The state has raised in its initial written submissions matters relating to the issue of contact between Mr Weeks and the New South Wales Police Force in 2007. I don't intend to go through those submissions again. In reply, there is a document referred to, and I think that which is a note of a telephone call involving a member of the Ombudsman's office. That note, I think the ringtail may have been a typographical error in my learned friend's submission. I think the correct reference is OMB.0009.006.0126. There's no need for it to come up on the screen, but all I'd say, Your Honour, is the date of that note is the 6th of March 2009. I'd observe that that's 2 years after the events in question, and that the conversation is between a member of the Ombudsman's office and a deputy principal at the school, and that Mr Weeks isn't a party to the conversation. It suggests that there was a meeting, as we know there indeed was, between police and Mr Weeks. The source of that information is unclear, and it is equivocal as to what exactly was said during the course of that meeting. I'd suggest there's little weight that can be placed upon it. That was the only matter, Your Honour, in that regard.
Thanks, Mr Fraser. Now, anyone else other than Mr Lloyd? Anything you want to say in response to any of those matters, Mr Lloyd?
There is, Your Honour. I anticipate I'll be no longer than about 10 to perhaps 15 minutes.
Let's continue.
Thank you. I'll deal first with the submissions made on behalf of Dr Patterson and Dr Hawkes, and just say at the outset that there's a few matters that I wish to draw attention to, but the fact that I draw attention to those matters shouldn't be taken as indicating that I accept the criticisms or submissions made, which I don't respond to. The position is that I adhere to the position in the written submissions in respect of each of the matters canvassed in the submissions in chief, to the extent that there are some amendments to the position in the submission served in reply. The first submission made on behalf of Dr Patterson, which I wish to deal with, is in these terms. It's a submission by Dr Patterson that the only clear incident of child sexual abuse that ever came to the attention of Dr Patterson while he was headmaster of Knox was the assault by Damien Vance. Your Honour and Commissioner, you'll recall that that was the position that Dr Patterson had adopted in his statement before he came into the witness box, and he adhered to that position at the outset of his oral evidence. The fact that Dr Patterson, in submissions today, still maintains that that his position is, in my respectful submission, something that does not sit well with the evidence that you heard in the course of the hearing in February and March. And may I draw attention just to one paragraph in my submissions in chief. It's paragraph 134. It's a short paragraph, and I wish to read it. The evidence Dr Patterson gave in paragraph 18 of his statement, and to which he adhered in his oral evidence, was plainly incorrect. By the conclusion of his examination, Dr Patterson had conceded that he was aware of multiple instances of potential or actual child sexual abuse, in addition to those mentioned in paragraph 18 of his statement. The serious allegations about Mr Nisbet in 1984 and 1986, the allegations about Mr Treloar in 1987, the allegations about sexual molestation of ATJ by Mr Stewart in 1992, the affair between Anthony Carden and ARZ in 1992, and the sexual assault of ARN in 1988. Your Honour and Commissioner will see that in that paragraph there are, in respect of each of those incidents which it is said Dr Patterson was aware of while he was headmaster of Knox, a footnote recording a reference to the evidence. Each of those matters, I withdraw that, in respect of each of those matters, the reference to the evidence is evidence that Dr Patterson himself gave on his oath to this commission. That is to say that despite the submission made today that the only incident of child sexual abuse that Dr Patterson was aware of was in respect of Mr Vance, Dr Patterson himself admitted to being aware of all of those matters recited in that submission, that paragraph which I've just read. In my respectful submission, the position that Dr Patterson still adopts is untenable. Secondly, a submission was made on behalf of Dr Hawkes that he gave what was called uncontradicted evidence that the first time that he found out that the police weren't called in respect of the assault on ARN in 1988 was when he came to give evidence at the Royal Commission. In my respectful submission, it's not to the point and not strictly correct to call Dr Hawkes' evidence on this point uncontradicted. It was put to Dr Hawkes by me that his evidence that he was not aware that the police weren't called was wrong, and in fact that he did know that the police were called. That is a contradiction to the evidence that Dr Hawkes gave. The submission was made by Mr Harrowell that the only basis on which Dr Hawkes was challenged was that he didn't see the police. But that's not right. Paragraph 140 of the submissions that I've made in chief refers to 6 separate matters supporting the inference that Dr Hawkes knew. That the first of those 6 matters is that he didn't see any police presence after the assault. But the second is that Dr Hawkes was in close communications with the boys in McNeil House, but none of those boys ever told him that they were interviewed by the police. Next, that Dr Hawkes was not interviewed by the police, and he knew that. Next, there was no report of the event in the media. Next, there was no evidence of any police investigation, charge or prosecution of the offender. And finally, that Dr Hawkes didn't see any of the staff at McNeil House being interviewed and was not aware that that had occurred. In my respectful submission, all of those matters support an inference being drawn that, contrary to the submissions made today, Dr Hawkes was aware that there was no police investigation into that assault. Next, a submission was made on behalf of Dr Patterson that he was not properly challenged in respect of the assault on ARN because he was not given appropriate details of what that assault was said to involve. Now, just draw attention to page 12449 of the transcript. And I'll just read the question that I asked Dr Patterson. A man dressed in a balaclava had positioned himself underneath ARN's bed and started groping his penis and testicles. Dr Patterson's answer, to his understanding, was correct. Next, you don't regard that as being a serious sexual assault? Answer, I've said it is serious. And in a number of other places in the transcript, Dr Patterson accepts that he knew that there had been, or that it was suggested there had been, a serious sexual assault on a boy in the dormitory. Finally, in respect of Dr Patterson's submissions, a submission to this effect was made by Mr Harrowell. Mr Harrowell said, it was not unreasonable for Dr Patterson to assume that an old Knox boy wouldn't do this, meaning abuse children. In my respectful submission, it was, at the time that that assumption was made, unreasonable to make it, and it would be today. It is unreasonable, in my respectful submission, for a school to assume, without conducting proper checks, that a person is appropriate to be employed as a teacher merely because they're an old boy at the institution. The fact that one is an old boy doesn't permit any assumptions to be made about appropriateness in place of the checks which ought to have been made. Can I just move on and deal with some things that Ms Bateman has said on behalf of Mr Fotis? First, Ms Bateman submits that the submission made by me at paragraph 57 to the effect that Mr Fotis at the time of his employment had a criminal record was false, and false to my knowledge, and presumably those instructing me. There's no basis for that submission that Ms Bateman made, and it should be rejected. I adhere to the submission which is made in paragraph 57. Next, Ms Bateman made reference on a multitude of occasions to what she termed what this commission loosely calls evidence. By that, presumably she's referring to the documents which were tendered and admitted into evidence during the course of the hearing, almost all of which, I note, were tendered without objection by any party who was present and had been granted leave to appear. Now, Ms Bateman says that Mr Fotis wasn't served with a summons. That matter, as I've said, I do not accept, but in any event it's irrelevant to any matter presently before the Commission. What is relevant, though, is that there is not a single thing that Ms Bateman has said, or, I pause to note, could say, which would persuade you that Mr Fotis was not given every opportunity and was not entitled to come along and seek leave to appear if he wished to do so. He had every opportunity to come here and object to evidence. He had every opportunity to come here and cross-examine any witness who he wanted to cross-examine. And for Ms Bateman to now, at this stage, come along and make statements from the bar table about the lack of probative value of statements which have been admitted into evidence without objection is entirely inappropriate in my respectful submission. That evidence is properly before the Commission, and much of the evidence that she referred to is of significant probative value. For example, it is abundantly clear from the body of evidence before this Commission that there was an assault on ARN in the dormitory in 1988. And further, on a related submission that Ms Bateman makes repeatedly about the credit of Mr Pearson, again, if all of those things were sought to be said by Mr Fotis about Mr Pearson, Mr Fotis should have exercised his rights to come along and put them to Mr Pearson so Mr Pearson could respond to them. That did not occur, and Mr Pearson's evidence should be assessed on the basis of what actually was put to him when he came in and sat in the witness box and gave his evidence. Finally, a submission was made by Ms Bateman that Mr Pearson's evidence about having interviewed Mr Fotis after the assault was opinion evidence. Well, in my respectful submission, that is wrong. The evidence, and I don't want to take you to it, is at transcript 12261, and Mr Pearson gave evidence about what he did, that is to say, interviewed Mr Fotis about things such as where he was at the time of the assault in order to investigate the question of who might have perpetrated the assault. It's not opinion evidence. Unless there's anything else, those are my submissions.
Thank you, Mr Lloyd. So we'll adjourn.
I don't think there's any other matter.
Nothing further? All right. Thank you.
Got to go down to the lunacy centre.